Good morning and welcome to this public meeting of the Consumer Product Safety Commission. Today we're here to be briefed on a draft final rule to revise the Commission's existing rule on certificates of compliance and to implement e-filing for imports. The draft final rule before us today would revise the agency's current regulations for certificates of compliance and implement electronic filing or e-filing of certificate information for imported CPSC regulated products and substances. E-filing with Customs and Border Protection will allow CPSC to receive the data and provide us insight into the shipments coming into the United States. This will enhance the agency's targeting and examination efforts to ensure the products under our jurisdiction comply with applicable safety standards and safe products move through the ports more efficiently. In a moment, I'll turn this meeting over to staff so they can brief us. Once they have completed the briefing, each commissioner will have 10 minutes to ask questions with multiple rounds if necessary. As a reminder, if you have questions that address statutory interpretation or legal advice, please don't ask them at this time. We can hold a closed executive session at the end of this briefing upon request. Here today with briefing us are Jim Daholsky, Director of the Office of Import Surveillance, and Mary House, Attorney in the Regulatory Affairs Division of the Office of General Counsel. Thank you both for being available today. And with that, please begin.
Good morning, Chair and Commissioners. This morning, Mary House and I will review the draft final rule to revise 16 CFR Part 1110, Certificates of Compliance, and the implementation of e-filing. Next slide. During the briefing, we will provide an overview of the final rule, including background and key benefits of e-filing, review the statutory requirements for certificates, as well as rulemaking background, review the history of e-filing related projects, discuss changes from last year's supplemental notice of proposed rulemaking, review staff's recommended draft final rule, provide an overview of the final Regulatory Flexibility Act and the Paperwork Reduction Act burden estimate, and we'll conclude by summarizing staff's recommendation. Next slide. The final rule will revise 16 CFR Part 1110, the agency's regulation for certificates of compliance, which includes requirements for both imported and domestically manufactured products. The final rule aligns Part 1110 with other CPSC rules for testing and certification. Additionally, private labelers will be required to certify privately labeled domestic products unless the manufacturer has already done so. The final rule also adds an attestation for all certificates and requires testing exclusions to be cited where applicable. After consultation with U.S. Customs and Border Protection, as required by statute, the final rule implements the electronic filing or e-filing of certificate data with CBP at the time imported products make entry into the United States. E-filing will allow CPSC to incorporate certificate data into our risk assessment of imported products, which will improve our targeting and examination efforts. Next slide. As mentioned, a key component to the update of Part 1110 is the implementation of e-filing. E-filing will allow CPSC to use data from a certificate to assess the health and safety risks of consumer products when they are being imported into the United States, and to better focus our examination and holds at the ports on products that are more likely to be non-compliant, while reducing inspection delays for compliant products. E-filing involves electronically filing the data from a certificate using a partner government agency or PGA message set. CBP specifically developed the PGA message set to allow the trade to file other government agency required data in CBP's single window, the Automated Commercial Environment, or ACE. CPSC is not unique in using a PGA message set. For years, more than a dozen agencies have utilized this functionality to receive additional required data. With e-filing, CPSC will process import shipments more efficiently and increase focus on higher risk products. Not only will e-filing help support CPSC's focused targeting efforts, but it also provides the trade with a standardized process for electronically filing product certificates. When e-filing, importers will have two methods for filing certificate data. With a full PGA message set, the importer provides their broker all product certificate information, and the broker files it in the CPSC message set. This is recommended for companies who import a limited number of regulated products or those that do not repeatedly import the same product. With a reference PGA message set, the importer pre-enters the certificate data into the CPSC developed and maintained secure product registry, and then provides their broker with certificate identifiers to be filed in an abbreviated message set. Reference PGA message sets are preferable if the importer repeatedly imports products covered by the same certificate. By using the product registry, the importer can leverage manual or bulk upload features to file certificate data in a streamlined manner. As long as the certificate details remain current, a product certificate can be referenced repeatedly as multiple shipments of the same product are imported. Next slide. Currently, CPSC collects certificates only after staff identifies a shipment for examination. Therefore, certificate information cannot be used for risk assessment purposes. E-filing will provide benefits to both the trade and CPSC. Importers that e-file consistent and accurate certificate data will experience reduced hold times for compliant products and fewer exams at import, which will result in reduced costs, a reduction in risk scores, and an enhanced process for efficiently managing certificate data. For CPSC, e-filing will provide our targeting of it will improve our targeting for high-risk products, including those arriving in the United States under the de minimis exemption, and reduce unnecessary inspections, which will save agency resources and maximize efficiency at the ports. And most importantly, help keep non-compliant products out of consumers' hands. I'll turn it over to Mary now to review the statutory requirements for certificates.
Good morning. Next slide. I'm first going to review the statutory requirements for certificates and then review CPSC's rulemaking history for certificates. Section 102 of the Consumer Product Safety Improvement Act of 2008, or the CPSIA, amended Section 14 of the Consumer Product Safety Act to require certificates of compliance for all CPSC regulated products. Manufacturers and private labelers must issue certificates. The CPSA defines the term manufacturer as any person who manufactures or imports a consumer product. Accordingly, manufacturers, which includes importers and private labelers, must issue certificates for all consumer products subject to a consumer product safety rule under the CPSA, or are subject to a similar rule, ban, standard, or regulation under any other law enforced by the Commission that are imported for consumption or warehousing or distributed in commerce. Next slide. Certificates for children's products, called Children's Product Certificates or CPCs, must be based on testing performed by a third-party conformity assessment body whose accreditation to perform such testing has been accepted by the Commission. Certificates for non-children's products, called General Certificates of Conformity or GCCs, must be based on a test of each product or a reasonable testing program. Next slide. Certificates must specify each rule, ban, standard, or regulation applicable to the product. For consumer products with more than one manufacturer, importer, or private labeler, CPSC may, by rule, designate one or more of such entities as the entity who shall issue the required certificate and may exempt all others from the requirement to issue a certificate. Next slide. The CPSA contains requirements for a certificate form, content, and availability. At a minimum, each certificate must identify the manufacturer, importer, or private labeler issuing the certificate, the third-party conformity assessment body on whose testing the certificate depends, the date and place of manufacture, and the date and place where the product was tested. A certificate must also contain each party's name, full mailing address, and telephone number, and contact information for the individual responsible for maintaining records of test results. Next slide. Every certificate must be legible and all contents must be in English. Contents can also be in another language. Certificates must accompany the applicable product or shipment of products covered by the certificate. A copy of their certificate must be furnished to each distributor or retailer of the product. Next slide. Upon request, the manufacturer, importer, or private labeler issuing the certificate must provide a copy of their certificate to the Commission and to Customs and Border Protection. In consultation with the Commissioner of Customs, CPSC may, by rule, provide for electronic filing of certificates up to 24 hours before arrival of an imported product. Next slide. The Commission has general authority to implement the certificate requirement pursuant to Section 3 of the CPSIA, which provides that the Commission may issue regulations as necessary to implement this Act and the amendments made by this Act. Next slide. This slide provides an overview of the Commission's rulemaking timeline. The Commission published the existing rule for certificates in 2008, just after passage of the CPSIA, as an immediately effective final rule. The requirements for this expanded certificate were required by November 12th, I believe, 2008. So this rule was in response to the thousands of inquiries the Commission received about the newly expanded certificate requirement, such as who must issue the certificate and how a certificate should meet the requirement that it accompany the product or product shipment. To clarify these issues, the existing Part 1110 tracks the statutory requirements in Section 14 for certificates, and it allows for certificates to be provided on paper or electronically, meaning a URL on the packaging or invoice or in a PDF format. For imported products, the product must be available to the Commission as soon as the product or shipment itself is available for inspection in the United States. For domestic products, the certificate must be available to the Commission prior to the introduction of the product or shipment into domestic commerce. To clarify who must certify products, the existing rule requires manufacturers to certify domestically manufactured products and importers to certify imported products. The existing rule does not define importer, but we note that historically CPSC staff considered the importer record, or the IOR, on CBP's entry form to be the importer responsible for certification. However, if the IOR is a broker, staff would typically call the broker to identify the authorizing entity. The preamble to the existing rule explains that this initial rule was streamlined, at least in its initial phase. The existing rule was not expected to be permanent, as the Commission explained when adopting the rule. With time, CPSIA's expanded certification requirements will become more routine, and CPSC then would consider whether this rule needs to be revised based on actual experience. The existing Part 1110 does not implement the authority in Section 14G4 of the CPSA to require electronic filing of certificates, or eFiling, for imported products. Section 14 of the CPSA also required the Commission to establish testing requirements for children's products. In 2011, the Commission issued 2 rules related to testing and certification. 16 CFR Part 1107, titled Testing and Labeling Pertaining to Product Certification, which is commonly known as the Children's Product Testing Rule, establishes protocols and standards for ensuring continued testing of regulated children's products periodically and when there has been a material change in a product's design or manufacturing. In 2011, the Commission also issued 16 CFR Part 1109, titled Conditions and Requirements for Relying on Component Part Testing or Certification or Another Party's Finished Product Testing or Certification to Meet Testing and Certification Requirements, which is commonly known as the Component Part Rule. Part 1109 sets forth the conditions and requirements under which voluntary testing or certification of component parts or finished products by a party who is not required to test or certify may be used to meet in whole or in part the testing and certification requirements in Section 14. Relevant to the draft final rule, Part 1109 specifically allows an importer or any other finished product certifier to rely on another party's testing or certification, but the required finished product certifier must issue the certificate in their name. The finished product certifier must also exercise due care in relying on another party's testing or certification. After issuing Parts 1107 and 1109, the Commission turned back to Part 1110 to revise the rule to be consistent with these new testing rules. So accordingly, in May 2013, the Commission issued an NPR proposing new definitions to align with Parts 1107 and 1109, and proposed to require e-filing certificates with CBP at the time of filing an entry. The Commission received over 500 comments from more than 70 commenters. Some of the topics covered by commenters included product certification requirements, such as who must certify products. Commenters discussed the definition of importer and opposed adding back the private labeler as a party responsible for certifying. Commenters discussed the certificate formats, contents, availability, including the proposal to add several data elements, the record-keeping requirements, adding 5-year record-keeping requirement for GCCs. People seem confused about component part certificates, and we got comment on that. Also, the CBP and CPSC infrastructure and whether the agencies had the ability to accept electronic certificates at that point, and also the cost and burden of e-filing. We note that in 2013, CBP had not yet implemented ACE, and CPSC's risk assessment methodology, or RAM, was still in a pilot version of the system. So from 2013 to 2023, the Commission took a rulemaking pause and conducted a series of projects aimed at helping to implement an e-filing requirement. Jim is going to review those projects in just a moment. In 2023, the Commission issued a supplemental notice of proposed rulemaking, or SNPR, on December 8th, 2023. The SNPR modified the 2013 NPR based on the comments received and lessons learned from e-filing related projects, such as the Alpha Pilot, the Certificate Study, and the Beta Pilot, and from pilot participant feedback. For example, the 2013 NPR had proposed that the importer of record, or the IOR, be the importer. Based on comments on the NPR, the SNPR proposed to broaden the definition of importer to include any party that could be an importer of record under CPB's definition, proposing to define importer as the importer of record, consignee or owner, purchaser, or party that has a financial interest in the consumer product being offered for import and effectively cause the consumer product to be imported into the United States. The SNPR clarified certificate requirements for all regulated products and substances and modified and added several new terms and definitions. Next slide. CPSC received 47 comments on the SNPR. This slide lists some of the topics covered in the comments. At least 19 commenters stated that the SNPR's proposed 120-day effective date was inadequate and recommended a longer implementation period, ranging from 6 to 24 months, to come into compliance with a final rule. The commenters argued that an extended implementation period would allow industry to implement the new changes, including organizing resources, hiring data personnel, integrating internal technological systems, onboarding importers for e-filing, reviewing existing compliance programs, developing internal procedures, and completing additional legal agreements between parties to assign certification responsibilities. Comments on definitions. The most commented on was the definition of importer and the distinction between a finished product and a component part. Commenters thought that broadening the definition of importer to include any party that could be an importer under CBP's definition made the definition too broad, stating that importers understand importer of record and think that broadening the definition would add uncertainty and confusion as to who should certify. Commenters also showed confusion between finished products and consumer component parts and which products must be certified. For example, with regard to domestic products, some commenters did not want to include the private labeler back into the mix. And for imported products, we received some comments saying that the manufacturer should still certify even for imported products. With regard to disclaimer message sets, commenters stated that disclaimer message sets were overly burdensome because they added time and cost to industry, which does not currently track when a product does not need a certificate. And the disclaimer requirement, they argued, reverses CPSC's 2016 enforcement discretion for adult wearing apparel. With regard to de minimis shipments, commenters requested that de minimis shipments, including mail shipments, be exempt from the e-filing requirement. FTZ importers sought a different e-filing solution, such as attaching only the most recent certificate for a product based on how products are entered into the U.S. for consumption or warehousing from an FTZ. Or they sought additional time to comply based on procedural and software challenges for these entries. Commenters also stated that CPSC underestimated the cost of e-filing and did not consider startup costs and filing fees. Next slide. Now Jim is going to tell you more about the Commission's e-filing projects and explain the draft final rule. I think we need another next slide.
Next
A
slide,
slide
yes.
behind.
Thank you. Since publication of the 2013 NPR, CPSC has made significant advances to improve its import program and prepare for full implementation of e-filing, while CBP was also modernizing its import cargo processing system. In and around 2016, CBP progressed in implementing its ACE system and the PGA message set. During this time, CPSC transitioned from its pilot risk assessment methodology targeting system to a full production system. In 2016 and 2017, CPSC conducted an alpha pilot in coordination with CBP involving 8 volunteer importers and their trade partners, who successfully e-filed a limited set of data for regulated products. CPSC then conducted a certificate study to assess the agency's ability to use certificates and the information on them for risk assessment and targeting. In 2020, the Commission unanimously approved a multi-year plan to implement an e-filing program at CPSC. And most recently, CPSC concluded a beta pilot with 37 volunteer importers and their trade partners, and has entered into a voluntary stage to allow up to 2,000 importers to test e-filing prior to full implementation. Next slide. The draft final rule is largely as proposed in the SNPR, but with some modifications and clarifications based on industry comments. The primary changes include extending the 120-day effective date and, depending on the method of importation, creating 2 effective dates. One that covers most imported regulated products subject to the final rule and those, that are domestically produced, and a second specifically for regulated products entered into commerce for consumption or warehousing from a foreign trade zone or FTZ. Several definitions were modified or added to address confusion and provide clarity. Certificate requirements, including the addition of an attestation, legal responsibility, and record-keeping requirements were also updated. The draft final rule also states that CPSC will not require importers to file disclaimer message sets for products that do not require a certificate. Disclaimer messages, which would be optional, can be used when a product falls under a harmonized tariff schedule code where CPSC would normally expect a certificate, but one is not required. For example, when a product is not within CPSC's jurisdiction or is within CPSC's jurisdiction, but no rule, ban, standard, or regulation requiring a certificate applies. Next slide. The draft final rule extends the effective date from the proposed 120 days in the SNPR. For all products regulated by CPSC subject to the final rule and required to be certified, except for those imported into an FTZ and subsequently entered for consumption or warehousing, the final rule would be effective 12 months after publication in the Federal Register. The 12-month effective date applies to regulated products that are imported as well as those that are domestically manufactured. The revised effective date is based on comments on the SNPR and feedback from beta pilot participants on the time it takes to prepare for e-filing. Additionally, beta pilot participants stated that their customs brokers needed to concurrently update their systems to be able to transmit the PGA message set into CBP's ACE system. Several brokers who assisted importers in the beta pilot estimated that this update could take 3 to 12 months with an average of 9 months. For domestically manufactured products, the 12-month effective date will allow manufacturers to adjust to changes related to privately labeled products, include the required attestation for certificates, and to begin listing any applicable testing exclusions. For CPSC regulated products imported into an FTZ and subsequently entered for consumption or warehousing, the final rule would be effective 24 months after publication in the Federal Register. Based on discussions with stakeholders, updating processes and software to meet the final rule will be particularly challenging for importers using FTZs. FTZ importers explain they require additional time before implementation to build the necessary infrastructure to accommodate accurate CPSC message sets and to troubleshoot issues. The first in, first out inventory accounting method applicable to fungible merchandise within an FTZ uses a unique identifier for inventory control and record keeping, which has no relationship to the compliance data CPSC requires. Currently, FTZ importers can only attach the latest certificate associated with an article supplier combination and cannot attach a specific certificate at the inventory level that CPSC's message set requires. FTZ importers will require significant changes to their current software to comply with e-filing. CPSC intends to work with the trade and CBP in the coming months to initiate conversations on software solutions that would best allow compliance with the final rule. Once a software solution is identified, meeting the e-filing requirement will involve software development, testing, implementation, and troubleshooting. Next slide. The definition of importer, as well as the definitions for owner or purchaser and consignee, are intended to harmonize with the Tariff Act of 1930 and CBP's implementing regulations that govern importation procedures. These definitions do not change CBP's requirements for parties eligible to make entry and are specifically limited to implementation of CPSC's e-filing requirement, and the party CPSC will hold legally responsible for issuing a finished product certificate. The final rule clarifies that the importer means the importer of record eligible to make entry for imported products under the Tariff Act, who may be an owner, purchaser, or authorized customs broker. The final rule addresses the concerns of commenters that an importer of record, such as a broker, may not have sufficient knowledge of the consumer products to be held responsible for the testing and certification. Accordingly, the definition also provides that an authorized broker who may identify the owner, purchaser, or consignee of the products who authorized the broker to make entry as the party responsible for compliance with CPSC's certificate requirements. A broker would identify such party when e-filing certificate data using the PGA message set. If identified as the certifier in the message set, the owner, purchaser, or consignee is expected to have sufficient knowledge of the products being imported and to understand that such products must now comply with U.S. laws and regulations, including compliance with CPSC's testing and certification requirements. The final rule also clarifies who is legally responsible for certificate data for products that are imported by mail or for which a de minimis duty exemption is claimed. These shipments do not have an importer record. Therefore, the importer definition specifies the importer is a party eligible to make entry for merchandise pursuant to CBP statutes and regulations, who may be an owner, purchaser, consignee, or authorized customs broker. Next slide. Other definitions in the draft final rule that have been modified based on public comments include owner or purchaser, which has been clarified to mean a party who has a financial interest in the imported product for which certificate data are required, including the actual owner of the merchandise, and may be held legally responsible for the data. A consignee is a party who takes custody or delivery of the imported product for which certificate data are required and may be held legally responsible for the data. The component part certificate definition has been updated to state that these certificates are voluntary and should not be e-filed. The finished product definition removes the phrase replacement parts and clarifies the three requirements that define a finished product, which are: the product is imported for consumption or warehousing or distributed in commerce. The product is subject to a consumer product safety rule under the CPSA or similar rule, ban, standard, or regulation under any other law enforced by the Commission. And the product is packaged, sold, or held for sale to or use by consumers. Next slide. For products required to be certified, the draft final rule explains that a certificate is required when the product is a finished product or substance. The product or substance is subject to a consumer product safety rule under the CPSA or similar rule, ban, standard, or regulation under any other law enforced by the Commission, and the product or substance is imported for consumption or warehousing or is distributed in commerce. The rule also clarifies that the requirement to certify products applies to finished products and not to component parts, and the obligation to certify regulated finished products rests with the finished product certifier. As for who must certify finished products, the CPSA requires that the manufacturer or private labeler test and certify regulated products. For domestically manufactured products that are privately labeled, the private labeler must certify or ensure that a manufacturer certifies the product. A private labeler can rely on a manufacturer's testing or certification to issue their own finished product certificate. For imported products, the importer must certify. Next slide. Importers using CPSC's product registry must periodically attest to the veracity of the data being filed. For e-filed certificates, even if the importer allows another party to enter certificate data into the product registry or to certify products on their behalf, the importer remains responsible for the information provided to CPSC. The product registry includes built-in simplified attestation requirements for both full and reference message sets. The draft final rule requires certificates to list all claimed testing exclusions instead of providing the date and place where a finished product was tested for compliance. The requirement to list testing exclusions on finished product certificate does not apply to Commission enforcement discretions. This requirement only applies when a statute or regulation allows for a testing exclusion. The product registry lists all testing exclusions for each rule, streamlining and standardizing how to record these exclusions on a certificate. Next slide. Certificates for imported products must be e-filed at the time of entry, except for products arriving via mail. Certificate data for international mail shipments must be entered into the product registry before the shipment arrives in the United States. Certificates for products manufactured in the United States must be issued on or before the product is distributed in commerce and must be made available to CPSC upon request. For imported products, importers are required to certify pursuant to Part 1109 and maintain the legal responsibility for the certificate data. The product registry is designed so that importers can allow their trade partners to enter data and even certify products on their behalf. The draft final rule simplifies the presentation of record-keeping requirements for all finished product certificates by stating that required records must be maintained for 5 years from the date of creation. Next slide. The Regulatory Flexibility Act requires agencies to prepare a final regulatory flexibility analysis, or FERFA, that explains the impact to small businesses. The FERFA concludes that the cost of the final rule to a small business is likely less than 1% of its revenue, and therefore does not impose significant cost to small firms. More than 270,000 small businesses are likely impacted by the e-filing final rule. The first year cost is expected to be $272 million in total, or $1,104 per firm. However, the first year cost of the rule will be the highest cost impact. When taking into account reduced costs after the first year, the analysis finds that the annualized cost is $16.5 million, or an average cost per firm of $67. OIRA has designated this rule to be a major rule based on the first year cost estimate. Next slide. This rule establishes a new collection of information for non-children's product certificates. It also expands the existing collection of information for third-party testing of children's products. The rule's additional information collection include additional record keeping for all manufacturers and importers of general use products, and new e-filing certificates for all importers of consumer products. These additional collections result in new burden for firms. For example, suppliers of non-children's products incur 147,638 hours of burden at a total cost of $5.25 million. Suppliers of children's products incur 209,759 hours of burden at a total cost of $7.46 million. Next slide. Staff recommends the Commission publish the final rule revising the certificate requirements in 16 CFR Part 1110, including the requirement to e-file certificates for regulated imported consumer products and substances. Staff recommends providing a final rule effective date of 12 months after publication for all regulated products except for those entered for consumption or warehousing from a foreign trade zone. For products entered for consumption or warehousing from a foreign trade zone, staff recommends providing an effective date of 24 months after publication of the final rule. That's the conclusion of our briefing. We would be happy to answer any questions.
Thank you very much for the briefing, for both of you, and for all the work that has gone into this. I know that has been a long time coming, and much work that's been put in by people who are here and people who have left the agency through that period of time as well. We're now going to move to questions from the commissioners. Mr. Trumka couldn't be here today, so his questions are going to be submitted for the record. I'd ask staff to respond quickly to those questions as well. I'm going to start with myself with questions. You talked a little bit about this, but Mr. Chholsky, can you explain how the certificate data obtained through e-filing is going to be used initially by the agency, and then how over time it's going to be used?
Yes, happy to. The key for us with e-filing is receiving this the certificate data. The data is much more granular than the data we receive now for products, the products that are being imported, as well as the entities in the supply chain that are associated with manufacturing and testing those products. And the key for us is using that information and combining it with the information that we receive now from Customs and Border Protection to improve our targeting and risk assessment. We see this really as a game changer for us in terms of being able to have this additional CPSC specific information that will enhance our targeting and allow us to do a much better job at import.
So also include data about laboratories that are used to test. So if there's a problem identified with a product, with this data, you'd be able to go back and identify the laboratory potentially at issue as well. Is that correct?
We would. That is something, unfortunately, that we are not able to do now. Currently, we only record test laboratory information when we collect a sample. It's part of our sample collection process. For products that we don't collect sample, they're examined and released. We don't retain that information. We don't have a database to be able to do that currently. So you're correct. We will have much more detailed information on testing laboratories that we will retain and we'll be able to reference back to in the future.
So if you did identify a problem with a particular laboratory, you'd be able to take a look at other products that are coming in that were certified and tested at that laboratory and be able to use that in your random system to be able to consider whether to target those for inspection.
Correct. Yeah, this gives us the certificate data, the eFile data will give us the ability to sort of expand our algorithms that we use for targeting and include data that we just simply don't have now.
Firms are concerned with how to comply with e-filing. What can they do now, and what do you expect to do with the rules adopted?
Yeah, a couple of things that we would recommend. We have, over probably the last couple of years, I think, built up a pretty extensive library on our public website relating to e-filing. There's a quick start guide. There's a product registry information, a number of reference documents, training videos that we've worked to put together. That's the place to start. I think, that is publicly available information that companies can go and become familiar with e-filing and sort of what it is and what you need to do. The other thing that we would highly recommend that companies consider is joining our voluntary test stage. This will give companies during the implementation period an opportunity to establish a product registry account and at their own pace begin to e-file. They can start to understand and work with their trade partners how they will organize their information, how they will upload if they choose to use the product registry, how they will do that, and then how they will transmit information to their broker so that it can be filed at customs. So that voluntary stage we do feel is critical. We have up to 2,000 companies that we can accept in that program, and we would encourage companies to do that.
An estimate about how many are participating now?
I think we have, between what's on board and what we have on a wait list, we're onboarding companies in batches so that we can give them sort of personalized assistance. I think we're around 300, I think is the latest estimate. So we have plenty of room within the test stage for other companies to join.
Can you talk a little bit about how eFiling can help with de minimis nailing?
Yeah, for de minimis in particular, I think as all the commissioners know, there are a large volume of de minimis shipments arriving in the United States every day. We have access to very limited information about those shipments that are coming in. As part of e-filing, there is no de minimis exemption under the CPSA, so de minimis shipments will be required to e-file. CBP is established an entry type 86, that will allow companies that are claiming the de minimis exemption to file an entry and attach CPSC required information, the e-filed certificate information. We will be able to bring that information into our RAM targeting system and be able to risk assessment, and it will give us much more visibility into the products that are coming in, but also give us a much better opportunity to target those high-risk shipments and stop them for examination.
We see a lot of de minimis products coming in under the commerce platforms that are out there, domestic and the foreign ones that are on the list. In that, person may purchase a product from manufacturer overseas, one-offs coming into the country, so fall under de minimis. In that situation, what's the role of the purchaser, person buying off the e-commerce platform, this versus a manufacturer sending it over?
Yeah, so for the purchaser, the consumer, that would be receiving the package. The rule specifically says that a consumer that's receiving a product for their own personal use would not be considered an importer and responsible for certifying that product. So we would be looking at um, other entities, in this case, probably the owner or purchaser, that would be the responsible party for testing, certifying, and then filing that data, or working with a customs broker to file that data to satisfy the e-filing requirements.
Thank you. Not 100% sure whether my microphone at the moment at the SEMA, but actually, Mr. Jaholski, your responses are more important than my questions. So at this point in time, I'm going to turn over to my colleagues. Mr. Feldman.
Thank you, Mr. Chairman. First, I do want to offer my thanks to Mr. DeWolski and his team for shepherding the e-filing initiative through to today's final vote.
This was no small task. As you noted in your presentation, e-filing will improve CPSC's ability to target higher risk products, reduce inspection delays, and increase examination efficiency. This will allow us to stop even more non-compliant product before they enter the country. For American families, every seizure of a dangerous or violative product is a commensurate reduction in the risk of illness, injury, or death. And each of the seizures represents a dangerous product that didn't reach American homes. And almost certainly, emergency rooms visits that never happened, homes that are still standing, and funerals that were never planned. A major challenge to keeping dangerous products out of American homes is the flood of direct-to-consumer shipments entering our country under the so-called de minimis exemption. These shipments often originate in countries that don't respect our laws, such as China. And as the U.S.-China Economic Security Review Commission, which you testified in front of, noted just last month, many Chinese companies are able to sell unsafe goods directly into the United States market and are unlikely to ever be held accountable for the harm their products cause. These products are further compounded by the limited capacity to monitor the millions of small parcels that enter the United States market duty-free each day under a de minimis exemption. E-filing changes that by improving the usability of the certificate data that we receive under Part 1110. This e-filing initiative, soon to be the Commission's e-filing requirement, allows CPSC to assess health and safety risks upon importation to the United States, improving the agency's targeting and exam efforts. Because the requirements also apply to de minimis shipments, the final rule represents an important step forward in our ability to keep American families safe from these known risks. In addition to Jim's Exis team, I also want to thank Brian Burnett, who I see is here, and his team from Exit, without whose technical expertise this initiative would not be where it is today. I also want to thank Mary House for her legal support and assistance with today's presentation and the rules development. While I plan to support the final rule, I acknowledge that there's additional work that remains to be done and want to ensure that the requirements become effective on a reasonable timeline. With that, I do have some questions. Staff is recommending a 12-month effective date. We've heard from a number of stakeholders requesting an 18-month effective date in order to stand up the infrastructure needed to comply with the requirements. Of course, we want to realize the full benefits of e-filing as soon as possible, and I don't want to needlessly delay the effective date. But Mr. Jaholski, in your view, does the record reasonably support an 18-month effective date for the non-FTZ filers?
I think it does, yes. We've, in the comments received in the SNPR and meetings that we've had with companies, we've received a range from 6 to 24 months in terms of recommendations from industry in terms of an implementation period. So I think 18 months certainly falls within that range.
Okay, great. That's helpful. I've also had an opportunity to meet with stakeholders to hear about the progress that they're making towards full participation in the e-filing program.
Some of them are beta pilot participants, some aren't. I've heard concerns about some of the technical aspects of the CPSC product registry, including concerns about the data structure, confidentiality, query capabilities, among other things. And I know staff are aware of these specific concerns as well, because you've sat through some of the same meetings that I have. But my question is whether staff plans to continue work on what I consider to be punch list items during the 12 or 18 months before the program's effective date.
We definitely do. I mean, we have, I think through the beta pilot and the voluntary test stage, we've received excellent feedback from trade, from our trade partners, not only importers, but customs brokers, software developers, coming back to us with great ideas on how we can enhance the product registry. We have a list of those enhancements. We're always constantly looking at prioritizing and reprioritizing them. And that will be work that will continue on through the implementation period.
And as that work continues, I assume that you remain in communication with stakeholders as you continue to build.
We definitely will. Just a couple of examples. We are going to be beginning to have office hours, virtual office hours, where the trade community can meet with staff. That will be an opportunity to provide us feedback and get into some of these details on ideas that companies have. We have our e-filing support at cpsc.gov email address, which is constantly monitored, and another opportunity to provide feedback. And then our staff has been very active in attending conferences and customs brokers meetings. And it's always an opportunity to provide not only outreach and education regarding to e-filing, but to get feedback as well.
I appreciate that, and I absolutely commend you on your responsiveness and for the presentation today. This is an important step forward, and I certainly appreciate all the work that's gone into it. I have no further questions, Mr. Chairman.
Commissioner Wall?
Thank you, Mr. Chairman, and thank you, Mr. Japolsky and Ms. House. I am very well aware of the decade, at least more, that both of you have been working on this, and to see it come to fruition at this point, I'm sure is very gratifying, and I appreciate all the hard work that has gone into this to date. So I do just have a couple of questions. Mr. Japolsky, I just want to sort of put this in context for a moment. Can you tell me the scope in terms of what percentage of products are regulated that would be subject to the requirements in e-filing within CPSC jurisdiction?
I don't have that number off the top of my head. I would have to go back and see if we can put an estimate. One of the challenges we have, I think, as you know, the harmonized tariff schedule codes are very broad. And so what we have tried to do is identify codes that we believe CPSC regulated products fall under. The issue is not every product that would be imported under those codes are a regulated product or even under CPSC's jurisdiction. So trying to put some of these estimates on that is very difficult to do, but I can certainly go back and talk to the team and see if we can get you an answer.
Okay, stepping back even further, that was a more detailed look that I was thinking of. I was just thinking broadly in terms of CPSC regulated products versus all the other products. Like regulated products are a small percentage of the products within our jurisdiction. Is really what I'm sure.
Oh, okay, sorry, misunderstood. Yeah, I think, products, obviously, there are a wide variety of products under CPSC's jurisdiction that are not subject to a mandatory regulation. Again, I don't have that difference, but you are correct. I mean, and as you well know, our regulations often are focused on children's products and toys and things like that, and those are the products that we tend to focus on at import.
To take one example, lithium-ion batteries and e-bikes, this would not address that. There's not a regulation on this.
Until there would be a mandatory regulation, correct, that those products would not require certification in e-filing.
I appreciate that. And again, I know you've talked quite a lot already about product registry. I just want to make sure I understand. Can you just give me a sense of the profile of the type of companies that have been using it and what our experience has been?
Yeah, I think generally the beta pilot certainly was skewed towards larger companies. And I think that's what not only CPSC, but other government agencies find. Those are companies that generally have the capacity and the resources to be able to commit to a pilot So that we've generally seen so far larger companies. I think, though, without a doubt, e-filing will affect a wide breadth of regulated industry, right? From small companies to very large companies. And there are challenges for both. In the registry, for example, larger companies are going to have to look to input into the registry and manage, tens of thousands of certificates possibly at any one time, or thousands or tens of thousands, it depends. And then you've got smaller companies that would have a much smaller, profile in the registry. One of the things that we've done is develop both the product registry and the reference PGA message set and the full message set as well. So for example, if a small company maybe imports only a few times a year, instead of using the product registry, they can provide all of the certificate information to their customs broker, and they can enter that information in the full message set. So they don't have to, although we've tried to make the product registry as simple as possible to use and as user-friendly as possible, they don't have to use that. There is another method to be able to file the data.
Understanding, in fact, is that there are some of the larger companies don't want to use the product registry because of the fluidity of products and parts product wise. Is that right?
That is true. We definitely have had engagement with one very large importer that has decided not to use the product registry and to go with the full message set. That's obviously a business decision. They have to look at their product line, what percentage of their products are required to be tested and certified, how often those certificates are updated. There's a number of factors that can play into making that decision, but it's a business decision that each company will need to make.
Yeah. Okay, I do have another question about budget. As part of our four-phased approach that the Commission approved in December 2020, item 4 refers to the need to, quote, dedicate ongoing resources. And in this uncertain budgetary environment, including the real possibility of cuts, I'd like you to explain how you envision the resources, how you'll be meeting that requirement to provide those resources.
Yeah, it's very, very tough question. As everyone knows, the budget is very uncertain. We're still working under a continuing resolution, unsure what the full year appropriation will be. For e-filing, we've identified two needs. There is an IT need, a need to maintain the product registry and the risk assessment methodology targeting system. So there are definitely IT needs. On the import surveillance project management side, we have one FTE that's assigned to this project full-time. And we also leverage contract support that up to this point has been funded under ARPA. I think we look forward to working with the Commission to try to keep those costs as low as possible, but also at the same time be able to provide the needed support for the product registry and also the support the trade is going to need for a new requirement.
Right, because in there's needs I had, the industry has talked about how expensive it is on their end and correspondingly at the agency level. So just it shows that as we're thinking that as a commission, our commitment through this rule, I need us to continue to think about how much it costs and whether to look those costs going into the future. So I appreciate your answer on that. I want to circle back on de minimis, if I can, and I know the chair asked about this, and you talked about the Form 86. Is that a mandatory form, or is that just optional? So it provides an avenue to provide the data set.
So currently, it would be optional for CPSC regulated products. The way that the entry type 86 is set up is if there is a requirement for other government agency data to be submitted. So in this case, e-filing, if approved, then the entry type 86 then becomes mandatory.
Share that. Thank you. Let's see. In the majority of de minimis cases, and maybe that's the answer to share, but I just want to double out on it. How would you characterize who the importer is? This case is who would be doing filing? Because in the package in this mini just question of grammar, I'm not sure. It says that the final rule requires de minimis shipments containing finished products regulated by CPSC to file CPSC's PGA message that the entry type capable and transmit use message, which is currently limited to Form 86. If you read that, it says that the shipments have to file. So who's doing the filing in those instances?
In the definition of importer, it says somebody who's eligible to make entry under CBP's statutes and regulations, which would be an owner, purchaser, consignee, or authorized customs broker. So any of those people. However, it would not be a consumer. We added that to the definition as well, typically not the consumer, because when you look at the shipping forms, the consumer's name often appears as the consignee. Right, so we would be looking to the owner, purchaser. If it's an authorized broker, they can do the same thing as part of the PGA message set. They can identify the person who authorized them to make that entry. That's the person we'd be looking at.
Okay. One final question, just on so that I'm clear on how this works, because it is complicated. In terms, I think you talked about this, Mr. Jaholski, about the importer of record. When it's a broker, they can then identify the consignee or the purchaser because they have the most information, and that makes sense. But I just want to square that with footnote 18, which you might not have that off the top of your head, so I will tell you what it says, that the party that the CPSC holds legally responsible, in this case, the purchaser or the consignee, for certificate data does not signify that this party is responsible for submitting such data into ACE, given that this party is not necessarily an importer of record or other party eligible to make entry under CBP statutes. So if they're not permitted or eligible to do the filing, I think that's what footnote 18 is saying. How does that square?
So I think that's specifically for a consignee. If you look at CBP statute, a person who can be an IOR, for example, is an owner, purchaser, or authorized customs broker. But a person who can authorize a customs broker to make entry is owner, purchaser, or consignee. So it gets really weedy once you get into CPB world, right? About who can make an entry is a different thing than who's responsible for making sure that product gets into the United States, who's responsible for making sure those products comply with our laws. So, but it's still limited to owner, purchaser, consignee, but there's a little bit of wiggle room in there because who's able to make an entry is not the same thing as who can do a certificate necessarily, but they're aligned.
Okay. I know I've gone over, so thank you, Mr. Chair. I appreciate it very much for all that you've both done. Thank you and the whole team.
Commissioner Ziak?
Thank you. I want to start by saying thank you to Mr. Jaholski and his team and the work they've done to establish over the many years the e-filing pilot, leading us to where we are today. I also want to thank our CIO, Brian Burnett, and his team and the work they've put into this, as well as Mary House and those at OGC involved in this project. I also appreciate this team's engagement with the stakeholders who participated in the alpha and the beta project pilots. This assistance was important to the Commission and provided critical feedback that moved this project forward. So thank you for all of your work and contributions keeping this project moving forward towards completion. For many, this will be a change to the status quo of paper filing. Commission staff has spent many hours reading comments, listening to feedback, answering questions in public meetings, and I appreciate the staff's demonstration of the e-filing platform to me and my staff in answering our many questions arising out of our own meetings with stakeholders. I want to be clear, this project should and will move forward. The landscape of consumer products is evolving quickly towards a digital world of e-commerce. This agency needs to evolve as well. This project is a critical first step towards that evolution. Take a few moments to share why I believe that e-filing is so important. As my colleague, the senior commissioner, has stated, Last month, the U.S. China and Economic Security and Review Commission issued its annual report. That bipartisan commission included a chapter about unsafe consumer products, many of which are coming from China. The commission made several recommendations, one of which is specific to what we are doing here today. That is the development of assessment tools to limit safety risks, considering the increasingly complex global supply chains. That is particularly true as we see the rise of foreign e-commerce platforms that enable direct-to-business-to-consumer sales. Since the beginning of this project, Commission staff has learned a lot from the pilot program, and companies who have been participating have been incredibly helpful in better understanding the effectiveness and issues of the new e-filing platform. We have heard from many in the industry who have expressed concern about certain issues with the e-filing final rule. We have listened, and we are working to address them. We want this to be effective in improving consumer safety while minimizing any disruption to the transition from paper to electronic filing. The work on the final rule continues, and the passage of the final rule will, in my view, not be the end, but the continuation of the work to bring CPSC's regulatory tools into the 21st century. My colleagues have asked many of the questions I had, so I appreciate that, and we'll be brief. I have one question. I think it's to Mr. Jaholski. On page 17, the last bullet, you had a discussion of the specific disclaimer set as optional. I want to better understand, because I think, based on our discussions we had yesterday, this will also apply if enforcement discretion is currently applied. That will remain voluntary. Is that correct?
That is correct, yes. That would be one of the scenarios where a disclaimer message would be optional and would give us more insight into the products that are coming in. But disclaimer messages, there would not be a requirement to file a certificate or a disclaimer message.
Great, thank you. Again, my colleagues have asked many of the questions I had. I appreciate the commission staff. I appreciate the stakeholders and everyone's work over the many number of years this has been going on. Thank you.
Thank you, everybody. Is there a request for a second round or closed session? Great. I extend my thanks as well to both Ms. House, Mr. Jaholski, and the whole team, some of whom I see sitting behind you as well, who've been working on this for a long time. Now we're going to conclude this public briefing, and thanks again to all the staff for their work on this matter.